I don't have to agree to anything, right?
You don't have to agree to anything. But this way, by coming to mediation, we have a chance to talk about things. We have a chance to make an agreement which would be written up as a contract, which would be enforceable in a court of law.
Just take a seat wherever you're comfortable.
In the past, most child neglect and abuse cases have been managed by social service departments and adjudicated by the courts, with legal counsel representing the interest of all the parties. This adversarial process has not always best served the complex needs of families in crisis. Plus, it takes a great deal of time for courts to sort out cases that do not lend themselves to simple solutions. Some jurisdictions are trying various methods of alternate dispute resolution. One of the most successful of these is mediation.
And now what's happened is that mediation has become a part of our court. It wasn't before, it is now. And what I mean by that is that the parties, all of the attorneys and the social workers and the judicial officers, we all look upon it as an extension of what we do in the courtroom. And we recognize that it can resolve problems that the court cannot resolve. It can resolve those court issues better than the court can resolve them. It can come up with more lasting results, that is, resolutions in which everybody buys into the result.
All the professionals are totally overwhelmed with cases. They don't talk to each other unless they're forced to do it, and then usually it's 5 minutes out in the hallway before they go into court. This is an opportunity for everybody involved to hear everything at the same time, to hear information that some of them have never heard before. Some attorneys from their own clients have never heard what they're hearing in the mediation. It makes all the difference.
One of the real advantages of mediation is that the people involved have the opportunity to create a custom solution that the court may not be able to do. The court has a certain list of remedies that it can order, but beyond that it can't go very far. The people at the table, however, have the opportunity to choose any solution that they think. For example, a relative may offer to pay for things or do things that a court wouldn't have the authority to order them to do, but they might voluntarily do.
What we have found time after time is that people have been through all attempts at settlement, are set for trial, think they have all the current case information. We walk in the door, begin talking, and they don't. And the information they don't have is the information they need that will help them resolve the case.
And Nina and my understanding is that John Tay has been in a permanent plan for some time, and it's been long-term placement. And there's been a recommendation from the department that that permanent plan change to adoption. And that's got to be one of the most difficult things that a parent would ever have to be faced to have to talk about. But that's our understanding of what we're here to discuss.
Dependency mediation focuses on fairness, privacy, self-determination, as well as the best interest of all parties, especially the vulnerable children who are the focus of the case.
And one thing you did say I agree with 100% is that John Tate do need you in his life, but he's been in my home long enough now that he needs me also, and my family, who he's grown up with.
Mm-hmm. Because, it brings everything into play because she's the young and the short time.
And one of the uncertainties.
I was very skeptical about mediation when it was first proposed. I think the other attorneys in my office were, as well as the attorneys in the other offices associated with the dependency court. It was something that was very new. I think as lawyers, there's always a certain sense and fear that maybe you're going to lose some control. And that is something that I think you work very hard to have in a trial process, to be able to make the case go the way that you want it to. And in mediation, it doesn't work that way. There were a number of discussions about what format the mediations would take, whether lawyers would even be involved or not. And there are different models for it.
A wide variety of mediation models are used in different jurisdictions. Sometimes the mediations are voluntary, other times court-ordered. Sometimes the mediation begins early in a case, when a social service agency calls for mediation at the case planning stage. but it can be called at any time during the life of a case, including the mediation of highly contested situations, such as deciding on termination of parental rights.
We don't get the cases that are going to settle somewhere else. We get the cases that are on their way or set for hearing or trial, for the most part. So in mediation, we tend to get the most difficult cases. And even in the most difficult cases, whatever the issue is that's been referred resolves most of the time.
Mediations have been used for everything from petty family disputes through the termination of parental rights. Cases frequently include violent domestic abuse, sexual abuse, and other complex matters that once were believed to be beyond the scope of peaceful discussions. Various jurisdictions have developed standards and practices for what types of cases they will refer for mediation, with some selecting only those they feel have the best chance of success. Others send all their contested cases to mediation and are pleased with the high rate of resolution.
I asked Steve Barron to come over, and naturally I picked 4 sexual abuse cases, the toughest, most severe cases that we get. And he resolved, through a mediation process, usually taking 2 to 3 hours, he resolved all 4 of those cases. This is over a 2 or 3 week period in one session each. Safety of the child was never compromised. The ability of the family to talk out the problems was the reason for the success. And all the parties in the process, and of course in dependency court there are many parties who are in mediation, came away believing that, my goodness, if we could safely resolve these issues, well, we can do anything.
In our program, we picked licensed therapists. In other programs, they may be attorneys who are experienced with family and juvenile court. They may be ex-child advocates. They may be probation officers. They may be contract mediators or therapists. Our model is we have a male-female co-mediation team, which we think is a real advantage because some clients are more comfortable talking with men than women. And other clients are more comfortable talking with women than men. And we'll disclose things to a person of a certain gender they won't feel comfortable disclosing to another.
And you know, sometimes the hidden agenda is not the issue on the table, not the legal issue. It's the emotional issue. They want I'm sorry, or they want to be able to explain why I did something. There's so much more psychological and emotional components to this than just the legal issues that are never allowed to be discussed in the courtroom, for instance. If you don't have emotion for some of these issues, like visitation, for an example, enforcing visitation, that doesn't get discussed in front of a judge, but it gets discussed all the time in mediation.
What guarantees do I have that I'll still visit? You don't let me visit some of the time. It's always a problem.
Your fear is based on
Yeah.
some past history of visits being canceled.
Right,
The
that-
role of the
that I won't-
mediator
that-
includes
that you'll
assisting the
adopt
parties in
that.
identifying the issues, fostering joint problem solving, and exploring settlement issues. This neutral third party encourages and facilitates the process without prescribing what the solution should be. The principles of mediation are based on communication, negotiation, facilitation, and problem solving. Mediation focuses on the needs and interests of the participants, fairness, procedural flexibility, privacy and confidentiality, full disclosure, and self-determination.
A family friend of Gloria's.
You know, we had a case recently, I think you probably observed a case, where a dad was brought in from jail to participate in mediation. And everybody, I don't know what they thought he wanted. Visitation, contact, a family placement, and he realized that wasn't best for the child. But the kind of setting where people are allowed to talk, to express some feeling, to vent, to be heard, really truly heard and listened to, produces change.
Gary has suggested that you will be supportive of what seems to be in the best interest of your daughter, hard as it is for you.
Yes, sir. So all I want is what's best for my daughter. I want her to have a chance at a good life.
You want her to have a chance to
Have a good life. To have a good life.
Depending on the community, participants usually include one or both parents, the minor child, caseworker, attorney for the parent, attorney for the minor, attorney for the Department of Social Service, guardian ad litem, or CASA volunteer, as well as others like kinship care providers, foster parents, or others involved in the case. Sometimes the court enters an order of those who must appear at the mediation, stating any parties or participants who are prohibited from attending the mediation and naming additional participants who may be included by court order or mutual agreement of all parties. Confidentiality relates to the full and open disclosure necessary for the mediation process to be successful. The mediator informs the parties of any limitations on confidentiality, such as mandated reporting of any new allegations of abuse that come out during the mediation session.
And one of the problems with child welfare is you want to be a social worker and do good things for the family, but you become an adversary as soon as you have to write those negative reports and take the stand and say awful things about the parents. And I think a large number of the child welfare workers have realized that there's a lot more social work in mediation than there is in a trial.
You know,
I never felt like you wanted me to be around.
Oh, no. I always wish that you would come around more because, you know, Jonte, I know he would love to see you when we're sitting down for Thanksgiving dinner. I know he would love to see you at the table, you know. And I would have loved to see that look in his eyes to see you sitting there.
Are you real? Really?
Yes, that's never been the door is always open for you to come. You're part of the family just like Jonte is.
Another positive that mediation has to offer is that it can clear up some misunderstandings between people. For instance, in dependency, sometimes the foster parents haven't met the parents before. And when they meet at the table, they actually don't envision a monster anymore. They have a human being in front of them who has feelings. And they can actually relate to each other through the child. Because normally they both love the children or the child. So that's where they connect.
And that we are in agreement here that we would try to certify that family friend as a foster family, that we will then move to get an adoption study, is that what you call it? An adoption study is started. That the
if an agreement is reached as to all or part of any matter or issue, including legal or factual issues to be determined by the court, the agreement is immediately reduced to writing, signed by the attending parties, and submitted to the court with copies to all parties and counsel.
In many parts of the country, the court is faced with probably three choices. They can accept the agreement as is, they can reject the agreement and either send the parties back to mediation if they had referred them in the first place, or proceed to trial. Or lastly, in some areas, the court might seek to change the agreement, but only with the consent of the parties, since it wouldn't be appropriate for the court to change an agreement unless the parties had also agreed to those changes.
If they resolved in mediation at that stage, there tended to be a significantly fewer number of contested hearings over the next couple of years.
But it saves all the trial time. For instance, the case that was set for a 5-day trial settled in 3 hours of everybody's participation. Just the attorneys, not the courtroom, not the bailiff, not the clerk, settled it there. And that's what happens 70% of the time.
Which is
And I haven't
plus.
any problem with the plan that you've worked out. That's fine. It sounds like a perfect way of handling a very imperfect situation. The only when we started mediation, I think I was telling you downstairs, I was very against it. I think a lot of why I was against it is because I didn't understand it. And I felt like it was taking away a big part of what my job was. And so it was very difficult for me to buy into the mediation concept. Then I started to find out, when I did send things to mediation, that the solutions that they came back with were very similar to the ones that I managed to kind of get people to buy into, but the real people, the parents, the children, the foster parents, the social workers, they were involved in the process, and so they had a hand in coming up with the solution. And their solutions were every bit as good as mine, and they worked better because they were the ones that solved their own problems.
And this was a huge change in the court system here, and it is in any court system. And Parents' attorneys in particular are very, very concerned about how mediation is going to affect their clients' rights and how confidentiality is going to work. How can they trust confidentiality when they don't know who these mediators are? So there's a tremendous amount of trust building with the players in the court.
An important part of successful implementation of a program is bringing together the key stakeholders, bringing together the agency in that county or state that serves to protect children, bringing together judges and court personnel, bringing together the attorneys that represent the agency for children, guardian ad litem, court-appointed special advocates, defense counsel, and others that are involved in child protection, and letting them begin to really shape their own program. Child protection in many ways is very local, and so solutions need to be found within the resources and capabilities and interests in a given community.
And I'm going to make an order that she not be removed from the home once she's placed. I'm going to make a placement from...
When parents and child welfare workers and attorneys can come together, knowing more than we could ever know, to figure out a resolution for a particular child, it's more likely to be a good resolution. I mean, there we are, sitting on the bench, dealing with all the rules of evidence and procedure and what you get to hear and what you don't get to hear as a judge, and then we're making a decision that is a life decision for a child.
There are many advantages to mediation. One is cost. In most cases, you can settle a case for a fraction of the cost it would take to litigate the matter. We don't have discovery, we don't have, a lot of hearings, we don't have a lot of paperwork and so on that is costly. And certainly going to court is costly. If you need witnesses and you have to pay people to be there, it can be extremely costly.
Well, the bottom line is mediation in dependency cases saves judicial time, empowers the parties, and fosters better outcomes for the children. That's what it's about.